Good morning, students. In this session of administrative law, we are going to revise the topic of delegated legislation. Now we'll look at and we'll revise the meaning and definition of delegated legislation. As delegated legislation, also sometimes referred to as secondary, subordinate, or subsidiary legislation, is a process by which the executive authority is given power by the primary legislation. So, to primary legislature to make laws in order to implement and administer the requirements of that primary legislation. And such laws is the laws made by a person or body other than the legislature, but with the legislature's authority. So as we have, in extensive fashion, we have already discussed all these things in class. We know that delegated legislation is one of the essential element of administration, whereby the executive has to perform certain legislative functions. However, we always need to remember and must not forget that what are the different risks which comes along with this whole concept of delegated legislation. And that's the reason why what are the factors which leads to this concept and to be known as like why delegated legislation is considered as a necessary, as an unnecessary evil even. When we look at the definition which is given by Salmond, it talks about that the delegated legislation is that which proceeds from any authority other than sovereign power and is therefore dependent for its continued existence and validity on some superior or supreme authority. So if we look at the definition and see it, that has sovereign wanted us to see the concept of delegated legislation. It says that it proceeds from any authority other than the sovereign power and is therefore dependent for its continued existence and validity on some superior or supreme authority. Now, the power here of subordinate legislation may be given to central government or state government depending upon the statute. Now remember the skeleton legislation, the okay, and the power flows from the parliament, the supreme the laws, legislation, if as I have told you, subordinate and supreme. If the legislature itself, the primary legislature, is legislating, that such legislation will be called supreme legislation. And if the legislation is happening from any other body other than the legislature, it will be, such legislation will be called subordinate legislation or secondary legislation. So now here, the power of subordinate legislation can be given to even central or state government depending upon whether the statute is a central or state law. And sometimes we have seen in classes also, we have discussed that central laws delegate legislative power to state governments too. And sometimes both the state and the central government derive rule making power from the same act. And some statute, they use the term appropriate government, which means that the central government or the state government having the powers in respect of the subject matter. Okay, like are other bodies on which the power of delegation is conferred, are some of the example that you have discussed are the Central Electricity Board under section 37 of Indian Electricity Act of 1910, or the Bar Council under section 49 of the Advocates Act of 1961. These are the examples we have already discussed in the classes. Or the Central Board of Revenue under section 59 of the Income Tax Act of 1922. So when we talk about these subordinate legislation, when we have discussed it already, so when we try and summarize the essence of it, we see that delegated legislation is even recognized by the Constitution of India. Article 13 subclause 3 defines law as including any ordinance, order, bylaw, rule, regulation, and notification having the force of law. So it was held that the words of all law in force in subclause K of Article 371F of the constitution includes subordinate legislation such as Sikkim government establishment rule of 1974. Okay, so when we look at the when we look at the difference between subordinate and the supreme legislation, you need to understand that the legislation, delegated legislation, are essentially a legislation made by any other authority other than parliament or state legislature. Okay, under the duty which is entrusted on them upon them by the act which is passed by the parliament or state government okay. And this subordinate authority which makes the subordinate legislation has to act within the prescribed limits of the parent act. We have discussed all of this in a detailed form already. Okay, now when we see look at the summarize the part or which talks about the nature and scope of delegated legislation, we see that legislation essentially is what is an act of making or giving or enacting law. So legislation is power to make law. So Salman has classified the legislation into two categories: supreme and subordinate or delegated legislation. So now supreme legislation is the legislation made by the supreme power in the state, that is parliament. Or subordinate legislation is the legislation made by the authority other than the supreme authority in the state, in exercise of the power delegated to it by the supreme authority. So the subordinate legislation is dependent upon the same superior authority or supreme authority for its continued existence and validity. This is what we have just discussed. Okay, and the delegated legislation is made by the authority other than the sovereign power, depends on some superior or supreme authority for its continued existence. So it can validly function or continue to function until unless the such power is been given to it by the superior authority. Okay, and the delegated legislation is made when lawmaking is delegated to the executive or the administrative authority through the parent act or enabling act. Remember the skeleton legislation that I have taught you about, then flesh in that can be filled in by later by the executive. Okay, so the power of lawmaking which has been given to the executive or the administrative authority by the superior body, the primary parent act itself. So the parent act needs to be made by whom? The legislature. So whenever the legislature is legislating, it will be superior or supreme legislation. And whenever any other body other than the legislature is legislating, doing enacting law or making law, it will be called secondary legislation. Now we look at the reasons for what which led to the growth and development of you know delegated legislation. What were the needs or requirement and which led to the growth for its growth. So we have already discussed that how the traditional constitutional theory we have just discussed in our previous session, which talks about the theory of separation of power between the three organ, and how the power should be divided. It proposes that the power should be divided between three organs. They should perform their separate functions. Then we talk about a concept like delegated legislation. We have to see that what led to the or what are the reasons which led to the growth of delegated legislation, and how and examine it in a manner that it has how it has been reconciled with the constitutional theory. And the causes for the growth of delegated legislation can be summarized as need it was considered as there was a lot of pressure on the parliament. So it was and because of that it was considered as a necessary evil, so it required for them to act and function, um, to for them to filling in details of legislation. And because they provide there was need for flexibility, a statutory provision which cannot be amended except by an amendment passed in accordance with the legislative procedure. So this process takes time, and however maybe it's necessary to make the changes in the application of the provision in the light of experience. It is therefore convenient if the matter is left to provided, left to be provided through subordinate legislation. So delegated legislation requires less formal procedures, and changes can be brought into, easily, much in an easy fashion. Then we had discussed that the technicality of subject matter and administrative administration. It works through administrative agencies, and have got the modern government. The change in nature or the character or the complex character of the modern nation, modern state, has brought it, has given them pluralistic functions, and they have to function through different administrative agencies and independent regulatory authorities, and which has to be regulated and monitor activities in the public interest. And like we have agencies such as election commission or reserve bank of india. All of them are expected to perform functions in the public interest, and each of these agencies are required to make rules and regulations in pursuance of its regulatory functions. So public corporation like life insurance corporation of india have the power of subordinate legislation. So when they are making rules and regulations to regulate themselves, they are performing function of subordinate. They are doing making subordinate legislations. So in order to meet emergency situations, the emergency measures, to take emergency measures. So we have already discussed that how the government may have to take quick decisions many a times in times of emergency, like right now you are facing something like this. All in future action cannot, and because we cannot just foresee the future, we could have never anticipated like something like this also will happen to us. So we cannot future actions cannot be anticipated in advance, and hence the provision cannot be made by the legislature all the time to meet all the unforeseeable situation or contingencies. So it it feels much more safer, and it was observed, and it was accepted that it's much more safer to empower the executive to lay down rules in accordance which it would use its emergency power. And thus the whole delegated legislation showed substantial growth during the times of the first two world wars, if we talk about, and especially during the time of emergencies. And now with the growth of international terrorism, and the question challenges that we face through climate change and other emergency health situations, we are seeing that legislations have to be enacted to combat these challenges, and such legislation are going to be are bound to be supplemented by subordinate legislation. Now we have, very in and very extensive manner, we have discussed all the types of delegated legislation and in what manner it gets, classified. So we have title-based classification, discretion-based classification, purpose-based classification, authority-based subdelegation, classification. Then we have nature-based classification. So, like if we talk about title-based classification, we have examples like of rules, regulation, bylaws, order, direction, schemes, are made by the authorities. And when we talk about discretion based, so it talks about, it has enabling act or extension and application of an act, and dispensing or suspending act, or acts which include something or exclude something. Okay, there are several examples that we have discussed already, which authorizes the government or executive to exempt certain persons or object from the operation. We have discussed it in the class nicely, like I had given you examples like payment of bonus act of 1965, which empowers the government to exempt any establishment from its operation having regard to financial position and other relevant circumstances. Okay, and now after that we have alteration act, which alters, which classification in which includes amendment as well as modification. Taxing act is there. Then supplementary acts under these legislation, administrative agencies are empowered to make rules to elaborate, supplement, or help in laying down some principles in the act. And approving or sanctioning act also. they which is not to just make rule but to sanction the rules framed by other specified authorities. Now we have authority based sub delegation classification that can be done, where the rule making authority cannot delegate its power unless the power of delegation itself is contained in the enabling act. Okay. And then we have nature based classification considered as a exceptional delegation also, where we have, when we see a normal delegation, we have positive negative. Positive gives you limitation, clearly defines the limitation of the delegative power would be clearly defined. Negative would be when there is no limitation, no definition is given, no boundary is being set, that on what matter you can legislate. All right, and then we have discussed nicely Henry 8 clause also, the clause which is applied to remove difficulty or removal of difficulty clause or exceptional delegation, under which wide range of power can be given to administrative agencies to make rules, including the power to even amend to remove any kind of difficulty which comes whenever an act is implemented. Okay. Like, for example, power to legislate on matters of principle, power to amend acts of parliament, power to make rules without being challenged in court of law. And these kind of legislation, as we have discussed, are not well appreciated, but uh, as it does not find much of acceptability even in Indian constitution. But when we summarize the power, the categories or the classification of delegated legislation, so we have power, legislations, delegated legislation which are often given to power to bring an act into operation. Okay. And now we will be moving further to discuss about the different what is the difference between conditional or sub delegation and delegated legislation. Now we'll look into the concept of subdelegation. So when we know that this maxim, delegatus non potest delegare, when a statute confers some legislative power on an executive authority, so the latter further delegates, and if that executive authority further delegates that power to another subordinate authority, it is called subdelegation. Okay. Now, as a maxim says, the delegate cannot further delegate the power conferred by it to on it by superior authority. This concept is based on this maxim, as we have already discussed. The delegate is non potest delegate, which makes that subdelegation unauthorized, and unless permitted expressively or by any necessary implication by the statute itself. So the subdelegation can be made when the parent act, impliedly or in an expressive fashion, empowers the delegate to do so. So if a parent act is silent on the issue of subdelegation, such subdelegation cannot be made. Okay. So now we'll move further, and we'll discuss and we'll revise the concept of conditional or contingent legislation. So when we talk about uh, you know uh, uh, your delegated legislation, that what is the meaning of this conditional or contingent legislation. So this delegated legislation further gets classified into subordinate and contingent or conditional legislation. So subordinate legislation implies that the subordinate or the dependent character of the agency which is entrusted with the power to legislate, and subordinate or ancillary character of legislation itself, the making of such agent is entrusted with. So if you look at conditional legislation, it says that the legislature makes the law in full and complete form. Remember, I've given you example of skeleton and then flesh, the gun and gunpowder. So the law will be prepared by the legislature in full and complete form, and there is no element of delegation of the law making power to the executive, but the said act is not brought into force and is left to the executive to bring the act into operation on fulfillment of certain conditions, okay, or certain contingencies. And This kind of power is given to the executive to decide whether the contemplated condition or contingency occurred or not to give effect to the act. Okay, and this type of delegation of legislative power to the executive, we call it as conditional legislation. So, conditional legislation is complete in itself, but it comes into operation, is made dependent on, it comes into operation and is made dependent to the fulfillment on of the certain condition. And what is delegated to an outside authority is the power accordingly, according to, its own judgment. The authority will decide that whether or not these conditions are fulfilled, and then to put in that act into operation. With which, we have discussed a very important case, Queen versus Bura, the Garrow Hill case. So you can again refer to that in, to revise further. So it tells us about it, how the it was held that the act of the the act in question was a conditional legislation, and the governor was not authorized to pass any new laws, but merely to extend the provisions of the act already passed by the competent legislature, and that to be upon fulfillment of certain conditions. Okay, and then let's look at the distinction between delegated legislation and conditional legislation. So when we talk about delegated legislation, it's a process consisting of discretionary elaboration of rules and regulation, whereas conditional legislation is the law that, legislation, the law is already made, but it takes effect when some conditions are fulfilled. Okay, and so in delegated legislation, the administrative authority, they provide they provide the manufacturer, the authority provides the gunpowder also. And in the conditional legislation, the gun and the gunpowder is provided by the legislature, and the administrative authority is only required to pull the trigger. So the example that I've used, remember in the classes, where I've told you that the act is ready only up when full on the fulfillment of certain condition, it has to be put into operation. Okay, so in case of conditional legislation, there is no element of delegation of legislative power per se. It is not open to attack on account of excessive legislation. But whereas, in case of delegated legislation, some of the legislative power is delegated to the outside authority, and the legislature, though is competent to perform essential or essentially, secondary legislative functions, performs only the essential functions, and the ancillary functions are given to the or delegated to the executive or the other authority. Okay, and since delegated legislation confers some of its legislative power on some outside authority, so this kind of legislation is open, to attack on the ground of excessive legislation. So these are the few points that you should remember always whenever you're talking about the difference between, the difference between delegated legislation or conditional legislation, and the concept of subdelegation. Now, in order to understand the constitutionality of delegated legislation, we have done a comparative analysis of this whole doctrine, that what lays limitation upon the delegation of legislative power, and constitutionality of delegated legislation, which essentially means the permissible limits within which the legislature can delegate its lawmaking power. So we have seen position in England, position in US, and position in India. So in England we have seen, because in England, Parliament is supreme, and so it has the power to delegate its powers to executive, but delegation should not be up to such limit that it should not abrogate the authority or power of the legislature itself and start determining the policies and laws all by itself. And when we had looked into the position of US, it is not recognized in theory, this whole concept of delegated legislation, because majorly because of two doctrines that we have already discussed: doctrine of separation of power and delegatus non potest delegare. So doctrine of separation of power says that it is accepted under the Constitution of USA, and Article 1 essentially talks about legislative power being expressively, conferred on the Congress, and judiciary having the power to interpret the Constitution and declare any statute unconstitutional. So, if it does not conform to the provision of the Constitution, so therefore legislative power cannot be delegated. And the second doctrine, according to delegatus non potest delegate doctrine, a delegate cannot further delegate its powers. So, as a Congress gets the power from people and is hence a delegate of the people, in that sense, it cannot further delegate its power, legislative power, to the executive or any other authority. But later, we have seen that because of the excessive, increase in the functions, governmental functions, it was not possible for Congress to actually enact all the statute, and it started delegating its power to executive, which got further challenged in court of law also. And when we talk about petition in India, so it is divided into two stages: pre-constitution period and post-constitution. So pre-constitution, we have seen that with the case also Queen versus Burra. I have seen the period, pre-constitution period, the power was dedicated only to the extent of conditional legislation, only to determine condition when the act would come into play, into force. Okay, and post-constitution, we have seen that there is nothing in the constitution, Indian constitution, which actually expressly prohibits the legislature to delegate. And we have discussed so many examples in this in our classes. So therefore, if the court had to find any restriction on the legislature in the matter of delegation, it had to be on the basis of some general theories and principles of constitutional law that we have discussed through judicial interpretation, that what are the limitation on delegation of this delegation of legislative power altogether. Now, in terms of finding out the impermissible delegation of function which cannot be delegated, or what are the essential legislative functions, or what are the limitations upon the delegation of legislative functions, we have discussed so many cases in the classes and our sessions. And as we have discussed that essential legislative functions, legislative power essentially means power of laying down the policy of the law and enacting that policy into a binding rule of conduct. So one of the most difficult question has been always to actually interpret the meaning of the this expression of essential legislative power when it is being applied to administrative rule making. And we have discussed so many case laws, and you can easily understand the meaning of essential legislative functions, or what are the permissible limits, with the case of Indre Delhi Laws Act of 1951, and in which Supreme Court observed that the legislature has sovereign powers to legislate within certain spheres, and it is free to legislate within those spheres only in any matter which appears to it to be the best way to give effect to its intention and policy. And in making a particular law, so it may utilize, or may give power, delegate its function to outside agencies to an extent which it finds necessary. So it can do anything, everything. Parliament can do everything, the legislature, which is ancillary, okay, and necessary for the full and effective exercise of legislative power. But it cannot abdicate itself from its essential effective exercise of legislative power. So it cannot get away from its essential legislative functions. And therefore, while entrusting power to any outside agency, that can be department or any public authority, it must see that such agencies act as a subordinate authority, and it should be ensured that parliament does not create a parallel legislature. And it's now it's a uh, there is although there is no agreed formula that with reference to which one can decide what are the permissible limits or delegated legislation, or when the law will be a bad law on account of excessive delegation. Yet because every case is decided in a different setting and special settings, but through the decided cases, courts have considered the validity of various delegating provisions with reference to this doctrine of excessive delegation, skeleton legislation. They have given the accepted power of inclusion and exclusion, power of modification of the statute, abdication test. We have discussed Venisbury principle, also power to impose tax, retrospective operation of delegated legislation, and many other, uh, acts like that.